last case is, excuse me, Lakeview Reserve Homeowners Association versus MARONDA Homes.
Good morning. May it please the court, my name is Patrick Howell. I'm here on behalf of the appellant in this cause, Lakeview Reserve Homeowners Association. I have with me here today Ms. Robin Braun, who's a partner at my office, and also Mr. Tom Slayton here on behalf of the Community Association Institute. Community Association Institute filed an amicus brief in this matter. This appeal is from an order granting summary judgment in favor of MARONDA and Thompson, ruling that the association does not have a cause of action for a breach of implied warranty of fitness and merchantability for defects to the association's common areas, and that, as a matter of law, an HOA could never have such a cause of action. The same order denied the association's motion for summary judgment on the same issue. The trial court erred by rendering summary judgment in favor of the appellees for two main reasons. First, Florida courts have historically protected consumers from unscrupulous builder vendors such that common law cases mandated a finding of an implied warranty. Second, the trial court erred because the record revealed disputed issues of material fact. The doctrine of caveat emptor is no longer the majority view for the conveyance of real property here in Florida. In fact, courts across the nation have continued to erode its application. In Florida, the courts have continually supported positions that protect purchasers from deficiencies caused by a builder vendor. Condominiums actually were the first to benefit from the modern trend here in Florida with the decision of Gable versus Silver in 1972. The Supreme Court based its decision on several factors. Some of them were discouraging negligent construction. Number two, the developer is in a better position to know of the defects. Number three, developers are in a financially better position to repair defects. And then number four, the importance of purchasing a home. The court focused on the fact that this is, by and large, the largest purchase that an individual will make during their lifetime. While the legislature did eventually codify some of the implied warranties for condominium units and common elements in 1976, the common law implied warranty of fitness and merchantability is still viable. While condominium common elements and homeowners association common areas are not identical property interest, they are very similar. They're similar for three reasons. Number first, unit owners in a condominium have title interest in the common elements, while an HOA lot owner has a property interest in the easement that they have over the common areas. Both of these are property interests that are recognized under the Florida Constitution. Also, both condominium unit owners and HOA lot owners are required to pay for the upkeep, maintenance, and replacement of the common elements / common areas. This is treated identically under the Condominium Act and Chapter 720, also known as the HOA Act. Also similar is the way that the legislature treats common elements and common property. They have created a scheme for taxing both of those properties in exactly the same way. As such, the public policy supporting the application of implied warranties for condominiums, common elements of those condominiums, should be the same for common areas of an HOA. The trial court erred by failing to recognize those parallels and apply the law accordingly. The modern disintegration of caveat emptor continued to expand with cases ruling that the implied warranty would also apply to the land beneath the home that was purchased. These cases recognize that purchasers should be entitled to purchase both the home and have an implied warranty as to the grounds beneath the home, and these are known as the package deal cases. This concept should also apply to association common areas because of the financial interest and the easement rights over the common area that are also a part of the package deal that a homeowner in Florida purchases along with their home. The trial court relied upon Conklin versus Hurley and Port Sewall in ruling against the association. But if you read Conklin closely, it would actually mandate a ruling in favor of the association. The appellees take from the Conklin case a categorical ruling that seawalls can never benefit from an implied warranty. And that's sort of the mistake also that the Port Sewall court took, the 4th District Court of Appeal took, and taking that and also making categories that include now roads and drainage systems. The mistake is that that's not what Conklin versus Hurley said. Conklin versus Hurley actually spends 2 pages focusing on Gable versus Silver, the case that started all of this, and the analysis in that case. In doing so, they looked at all of the different things that I mentioned before, the intent of discouraging negligent construction, the fact that the developer is in a better position to know the defects, and then the last one, the importance of purchasing a home. In Conklin versus Hurley, that wasn't the situation. The land that was being purchased was raw, unimproved land, and the purchasers were actually investors. They weren't lot owners, or they weren't homeowners. So the last factor from Gable versus Silver, which is probably the most important one, the importance of purchasing a home, had no application in Conklin versus Hurley. The 4th District Court of Appeal didn't look at that analysis and instead sort of created categories. The trial court followed that ruling and said that as a matter of law, roads and drainage systems can never have an implied warranty because, according to the trial court, that's what Port Sewell said. However, this court has previously pointed out in Lockran Engineering that the principles from Conklin should be narrowly construed, and they should be narrowly applied to unimproved land. It's also important for other insight. In that decision, this court makes it clear that it's a breach of warranty, breach of implied warranty cause of action, not a negligence cause of action. That's the proper theory of recovery for a party that's experiencing construction defects. This nullifies some of the arguments that were made by the appellees that the association just chose the wrong cause of action. Also, the court in Lockran applied an implied warranty to a septic system. So conceptually, the question comes, why would it apply to a septic system and not to a stormwater system, or never to a stormwater system, as the lower court would have said? Appellees will argue that Lockran is inapplicable because no HOA was involved. 2 points of rebuttal. First, in Lockran, there were 5 duplexes using one septic system. So concepts of joint use and joint ownership were involved in that case. Secondly, that thought process would call into question the 4th DCA's decision to apply Conklin, a non-HOA case, to Port Sewall, which was an HOA case.
Counsel, is there a point, if we were to accept your argument, where does one draw the line? And here I'm thinking, is this something for the legislature versus the courts? If your argument essentially is that roads and drainage systems are so important that they ought to be included in the implied warranties. I mean, would the same warranty requirements hold true if, for example, if the developer puts in a tennis court and a guard shack at the front door and front entrance of the facility, and that it falls down, or tennis court turns out to be a bad tennis court? I mean, is that within or without the implied warranty? Is there a line drawing, and if so, where do we draw it and how do we draw it?
Your Honor, I think that To answer that question, first of all, tennis courts have been found to have an implied warranty in the condominium context. And so something that does not, quote, support the residences has been previously and by a different district found to be something that warrants an implied.
Is that based upon a statutory claim or a common law claim?
It was the implied warranty as set forth in the statute. Okay. And so it was.
We don't have that statutory framework to rely on. So I'm trying to understand, if you were writing the opinion in this case, what would be the principled place to draw the line, and how would we make the distinction?
Well, Judge Orfinger, I think what I would say in response to that is that there is no line. That what Conklin versus Hurley and what the court in Gable versus Silver mandated is that each case be looked at on a case-by-case basis, and that based upon the factors that I mentioned before, and based upon the status of the parties, is there a lender involved that owns the property and selling the property, or is it a developer? Do we have a homeowner that's purchasing a home? Is it a residential situation? And then applying all those other factors that they referenced, what does justice require? And so, I don't believe that there is a bright line, and in fact, that I believe was the mistake that the lower court, and possibly also the Port Sewell court made in establishing these categories and saying that, okay, roads can never have an implied warranty, that drainage systems can never have an implied warranty, that seawalls can never have an implied warranty. That's not what the Conklin court was trying to say. What they were trying to say was there's an analysis, and you've got to look at everything, and then you've got to make the decision. The lower court in this case didn't do that. Instead, what they did was they looked at categories, and they said, Sewell mentions bridges, roads, and drainage. Therefore, I'm sorry, Mr. Howell, but your client's claim is out. That's not the analysis that I think the Supreme Court wants courts to apply in implied warranty cases. The other thing to keep in mind about the Port Sewell case is, like I said, the defendant in that case was a lender. It wasn't the developer that constructed the defective roads or the drainage systems. Taking that out of the equation and looking at the different factors that Gable versus Silver imposes, that takes out 3 of the 4 main factors, which was the intent of discouraging negligent construction. The lender didn't construct it, so how would that policy have been moved forward by Port Sewell? The developer is in a better position to know the defects. Again, a lender's involved. They didn't construct this stuff. The developers aren't financially better positioned to repair the defects. It was the lender, not the developer. So there are also other reasons that Port Sewell was distinguishable, and the trial court below could have chosen not to apply it to that situation. Also, I think that it's important to point out that when Port Sewell was decided in 1985, Florida was just a different place. HOAs were around, but they weren't as pervasive as they are today. For instance, in 1980, there were almost 19,000 HOAs and planned communities in the country. By 2009, there were almost 160,000 such communities. And so every day, new HOAs come online here in Florida, and those HOAs are the guardians of the things that local governments used to take care of, whether it's parks, whether it's roads, whether it's drainage systems, whether it's underground pipes. It's now the homeowners that are required to pay for those different elements, and if they're defective, fix those elements through the payment of their assessments. The local government is no longer involved. So for that reason, I think that the 5th District Court of Appeals should move forward with the analysis that was set forth by the 2nd DCA in the Strathmore Gate East at St. Lake George case. That court, the 2nd District Court of Appeals, stated, "We believe that as the owner of the common areas and with the responsibility of maintaining them, a status which the developer created for the benefit of the homeowners, the association has a cause of action against the developer for any defects in the construction of the common areas." Looking at that opinion, one of the things that will be pointed out by opposing counsel is, well, they don't really tell you what the cause of action is. But looking at the words, we know that there are several causes of actions that it is not. Number one, it says a cause of action against the developer. So that we know that they're not talking about a breach of fiduciary duty against the prior developer appointed board members, because it says that the cause of action is against the developer. We also know that it says for any defects. Therefore, we know that the Second District Court of Appeal wasn't talking about just building code violations or a violation of the building code statute. So we know that it's a broader cause of action. Based upon this court's limitation of a negligence cause of action in these circumstances, we have cited two opinions in our briefs that do so. We know that that leaves us with implied warranties. So what we're asking the court to do is to follow the Second District Court of Appeal, expand upon what the cause of action is, that it is a breach of implied warranties, and reject the analysis from the Fourth District Court of Appeal. The other portion of the analysis that was looked at by the trial court that I think is important to distinguish is the fact that even if we were to look at the whole support argument or immediately supporting the residence argument, that even if that had been applied and we were to follow the Fourth District Court of Appeal and that sort of reasoning, in this circumstance, we still would have had a finding for the association and a denial of the summary judgment. That's because in our motion, we had attached to the motion, or we filed separately with the motion, the affidavit of James Campbell, who was the vice president of the association, and he testified that, in fact, the roads, the drainage, the underground pipes, and those different elements do support the residences. And so that was not rebutted by opposing counsel.
Question?
Yes.
What qualified him to make that statement? I mean, it's a bald-faced assertion, but what qualified him to be able to credibly make that assertion?
Well, he did two things, Your Honor. First of all, he referenced the report of the engineer that had been retained by the association to review the defects. And so he commented on the engineering report of that expert. And then secondly, he lives there. He knows how important the drainage system is to Lakeview Reserve. It was built in a watershed that goes from a height down to Lake Apopka, and there was actually a stream or creek running through what is now the neighborhood at the time. So he knows that historical background. He knows how important the pipes and the drainage system is to the community and what would happen if those systems failed.
Is that a factual question, though, or is that a legal standard, whether or not it's supportive of the residents?
Well, if the court is going to take the Fourth District's analysis and say that we're only going to apply implied warranties to a situation where there is a support of the residences, then I believe at that point it becomes a factual question if you're going to take that analysis. If there's going to be categories where you say, well, one court has said that roads can never have an implied warranty, then it becomes a matter of law. But if you're going to use the whole support analysis and decide on whether it does in fact quote support, I think that there has to be some sort of factual basis for that. There has to be some testimony, expert or otherwise, as to how and why it does support it. We supplied that, but that was not supplied by the other side in rebuttal.
As pointed out by Judge Orfinger, in the absence of a statutory framework, is the Supreme Court's decision in Conklin a mandatory authority for us?
Is the analysis that is supplied by the Supreme Court mandatory? Mm-hmm. Yes, but I think that analysis is what lends or tends to provide us with a ruling in our favor. Because
even where Judge Adkins specifically pointed out in his dissent that there were certain improvements, for example, roads was one of the examples he used, to which he would not extend implied warranties?
Well, Your Honor, what I would say is that historically there are changes. Today, when you develop a community in Florida, it is going to have a mandatory association, and there's a very good chance that the roads are going to be private roads that are maintained by the association members, not some governmental
All I'm
entity.
asking you is that even if I would agree with you on that, in the absence of a statutory framework, if there's a Supreme Court case saying that those implied warranties will not be extended, how is that not mandatory authority on us?
I don't think that the dissent in that opinion is binding upon this court. And I think that this court can recognize that the opinion was written at a certain time and that things have changed, and that roads, which would have been the responsibility of perhaps a governmental entity back in 1972, will be the responsibility of private homeowners in 2010. And so I don't think that there is anything wrong with moving beyond that, especially considering that it's dicta in a dissent.
Well, Atkins was agreeing or disagreeing with the majority that a seawall was not supportive of the residents, but then went on to say, which would seem to support that he was agreeing with the majority, and that the majority was saying the same thing he was in his dissent on this point, that there are certain improvements to which implied warranties would not be extended, and he used the example of roads. Do you agree with that?
I do agree with that, but that's not what the majority said. And so I do not see this as being an establishment of categories. And that is what the 4th District Court of Appeal has done, arguably, and that's definitely what the trial judge did here, that there are categories, and you can never have an implied warranty as to roads. You can never have them as to seawalls. You can never have them as to drainage systems. And I don't believe that's what the majority in Gable v. Silver wanted. I think they wanted an analysis where you take the different factors, you look at the parties involved, you decide whether or not it's a residential purchase, and then you make your decision. And that's what I'm asking the court to do today. That's what my client's asking you to do.
Counsel, you've exhausted your time, but it's an important issue. I'm going to give you 3 minutes for rebuttal if you feel you need it, and I'm going to add it to your time.
Okay. Thank you, Judge.
Good afternoon, Your Honors. May it please the Court, I'm Steve Brannick of Brannick & Humphreys, here representing the appellee Maronda Homes. I'll be splitting my time 15 and 5 with Mr. Pickert, who is a co-appellee representing the site contractor, T.D. Thompson. Where do we draw the line? The cases tell us where we draw the line. The line is drawn at the front door of the home. If there is damage to a home, then the implied warranty provides a remedy. If there's no damage to a home, there is no implied warranty. And as I
Do
said,
the homeowners, or does an HOA have, what remedy would they have if the roadways were poorly constructed and fell apart or something? What is the remedy if there is one?
Other possible remedies might be express contractual warranty if there is a contract, fraud, negligent construction, perhaps a negligence action against the professionals who were involved, the engineers, for example. So there are other possible remedies that might apply. Of course, we didn't explore those remedies in this case because the Homeowners Association chose only to bring the implied warranty of merchantability remedy. We think that this case was essentially settled by the Conklin v. Hurley case back in 1983. In that case, the court was asked precisely the same question that's being asked of this court, which is, does the implied warranty that was provided by the Gable case extend beyond the home to other improvements to the real property? And the court specifically answered that question, no. If there's not damage to a home, the implied warranty does not apply. And the court, I think, made 2 points in its analysis. One, it noted that it was departing from very long settled common law, so that it wanted to tread very carefully. But then secondly, and this is seen throughout the opinion, it emphasized that the Gable decision and all of the other decisions that were being decided around the country were focused on the protection of the home, the protection of the residents. And looking at those cases, it found no cases that extended the implied warranty beyond the home itself, and then made the decision in this state that the implied warranty would stop with the home. If you don't show damage to a home, there's no implied warranty. Interestingly, as you mentioned, Judge Roberts, there was a very vigorous dissent by Justice Atkins. It was a 4-2 decision, and Justice Atkins could have been up here making precisely the same argument that counsel made. Justice Atkins, in his analysis, said exactly the same things, that all of the policy reasons that the Florida Supreme Court cited in the majority of the opinion should apply to the seawall as well. The majority obviously considered those arguments very carefully, and looking at the case law around the country, where the case law focused on the protection of the home, decided that the implied warranty would stop with the home and would not extend to other improvements in the property. So the Supreme Court has considered these very arguments and has rejected them. And in fact, I think we have an even tougher case here for the Homeowners Association, because we're talking about roads and ponds and drainage systems, and even Justice Atkins, who had been a very vigorous proponent of extending the implied warranty to the seawall, said in his dissent that the implied warranty would not apply to something like a road. So even Justice Atkins would not have gone so far as the Homeowners Association did here. Applying Conklin v. Hurley, the 4th DCA and the Port Sewell case has reached precisely the same conclusion that we're asking the court to reach here on almost identical facts. It was a case relating to drainage systems in common property, and the Port Sewell case applied Conklin v. Hurley and said that the implied warranty does not apply. And courts around the country, and we've cited these in our brief, have reached the same decision. The San Luis Trail case in Missouri, the Campbell case in New Jersey, the Bloomfield Club case in Illinois. Courts around the country are reaching the same conclusion. We don't think that the condominium cases that are being cited by opposing counsel are helpful for a couple of reasons. First, the seminal case that they cite is that Drexel case. That was actually decided a few years before Conklin v. Hurley, so it was already on the books. And even though Drexel says that in the condominium context you can imply the warranty beyond just the residence to the common elements, obviously Conklin v. Hurley took a different view in the subdivision context. And I think the reason for that is that condominiums are very different than a subdivision. Factually speaking, it's much more difficult in a condominium to separate exactly what is a common element from the structure of the home. If you look through the condominium cases, most of them concern problems with the roof, problems with windows. Well, a problem with the roof is in the actual structure of the home, so clearly it's going to impact the home. Obviously, a problem with a window is going to impact the home, and so even though the roof may be a, quote, common element in the condominium context, it's much more directly impacting upon the home, which is why I think in the condominium context, courts have at least stated that they're extending the implied warranty beyond the home itself to those common elements, but I think they do that because it's more difficult to draw the line. And interestingly, we don't have really a clean case in the condominium context where we're talking about damage that takes place to a structure completely divorced from the home, like damage to a tennis court or damage to a swimming pool. There's not a clear case in Florida that has actually applied the implied warranty in the condominium context in a situation like that. So it may be actually a little overbroad to say that the condominium cases are different from the subdivision cases, because we've never really been presented with that case. Counsel mentioned the Stroshine case, which was a tennis court case, but as you pointed out, Judge Orfinger, that was a statutory warranty case. It was not a common law implied warranty case, so we just don't have an implied warranty case yet in the condominium context that applies to what I would call a pure common element, completely separated from the residence. So all of the condominium cases that have been decided so far actually are cases where there is a direct impact on the residents.
Sir, if I may, I take it what happens is Maronda Homes, as a developer, breaks ground, they do the site work, then they start marketing lots, and at some point when they have reached a certain number of sales, they turn it over to the homeowners association to be responsible for the work that they did or had somebody do for them, the drainage, retention ponds, the roads, maybe a swimming pool or a tennis court or something like that. Is that correct?
That's correct.
All right. And then since the standard for a motion for summary judgment is to take the facts as true and in the light best suited to the non-moving party, which would be in the light best suited to the homeowners association against you. Is that right?
correct?
Okay, so if we if we apply that standard and we accept that, in fact, the roads or the retention ponds or the drainage in this particular case were defective, then can you articulate clearly for me what would be the remedy, specifically what would be the remedy for the homeowners association in order to fix work that was done by the developer or somebody that worked for the developer, and now they have the responsibility to fix something which, for argument's sake, in this setting, motion for summary judgment, is defective and has to be remedied? What is their specific legal theory that they get to do that?
All right. In some cases, there may be an express warranty, so that may be a theory.
Okay.
In other cases, there may be a negligence cause of action. That negligence cause of action might be against the developer, the contractor, or it could be against the professional engineers. The economic loss rule, for example, wouldn't apply to block an action against professional engineers who are negligent in the performance of their professional functions. Other cases mention breach of fiduciary duty claims. There's also potential fraud claims, potential fraudulent or negligent misrepresentation claims. As I said before, obviously none of those theories were explored here because they chose not to bring those theories, but there are other cases where those sorts of theories have in fact been successful. So those are the other causes of action that may be available. Now, I understand that it does raise a policy issue, and the policy issues have been discussed kind of on both sides of the brief about the difficulty of finding that express warranty, for example, in the context where the developer turns over the property to the association. And I think that perhaps might be their best argument. But this is an area that's been very heavily regulated by the legislature. If you look at Chapter 718 that covers condominiums and Chapter 720 that covers subdivisions, there's about 100 pages of statutes for the condominium context, about 40 pages in the subdivision context, covering these very particular areas, and the legislature has chosen, weighing those policy concerns, to provide the implied warranty in the condominium context. And so you have that statutory warranty in 718. The legislature, for whatever reason, has chosen not to provide that same remedy in Chapter 720. So I think that the weighing of the policy arguments, particularly in light of the long history of the cases that we have here, is an argument that really is best made to the legislature and not to the courts. So because of the fact that the legislature has, I would say, taken the field here and regulated both subdivisions and homeowners associations and condominiums very thoroughly, that the legislature should be the body that should determine whether that implied warranty should extend any further as opposed to the courts. Just one last point that I'd like to make before I turn over to my co-appellee, which is whether there's a fact issue here. In the trial court, there was no fact issues litigated. In fact, this issue was argued on cross motions for summary judgment. In the other side's motion for summary judgment, they specifically said that there were no disputed issues of material fact, and that's absolutely true, because there are no facts here that suggest that there is any damage or threatened damage to any home. The statement by Mr. Campbell in his affidavit that the roads and the drainage systems directly support the home, that's a legal conclusion. The facts here are undisputed. We know exactly what the defects were. We know that in terms of the defects that apply to any particular lot, at most we have some standing water and some erosion problems, but there was not a shred of evidence anywhere in the record that any of these problems in the common areas threatened in any way any of the residences or caused any damage. And of course, we are 6 years into the completion of this subdivision, so clearly if there had been such evidence, we would have seen it. So in terms of material facts, there are no material facts in dispute. The trial court was correct to rule on summary judgment, just as the appellants had invited the trial court to do. And so for those reasons, we think that this court should affirm, because they have two big problems. Number one, there's no damage to any home, so the Conklin v. Hurley case applies. And number two, even if there were damage to the lots or the homes, those would be an action by the homeowners themselves and not by the homeowners association.
Before you sit down, talk to me about the Strathmore case.
The Strathmore case, I think it's squarely within Conklin v. Hurley because it related to a septic system. And you recall that the certified question in Conklin v. Hurley was whether the implied warranty extended beyond directly supporting structures, including a well and a septic system. So the Florida Supreme Court had already determined that a septic system was a directly supporting structure, and that's exactly what the court faced in the Strathmore case. So I think it's squarely within the holding of Conklin v. Hurley.
Does a septic system is within Conklin, but what about a sewer system?
If it's a sewer system that's draining waste from the house, yes.
What about if it's a drainage system that's draining water from the property?
Only if that drainage system has an impact on the house itself. That would be, for example, the Hessen case or the N. Ray Barrett case. Both of those cases were cases where there were drainage problems on the lot, but those drainage problems in the Hessen case, we had settling, and so there was a problem with the lot, and so we had foundation cracks in the house. Clearly an easy case because you had damage to the house. In the N. Ray Barrett case, we had drainage problems that caused flooding inside the house, again, damage to the house. So if there is a drainage system that actually causes damage to the home, I think at that point in time it could be covered by the implied warranty. But otherwise, just as the seawall in the Conklin v. Hurley case, as Justice Atkins pointed out in his dissent, if the seawall collapses, perhaps it could cause significant erosion in the property, and perhaps that could undermine the foundation of the house. Obviously, the Florida Supreme Court decided that was too attenuated, and without the specific showing of damage to a house, the Supreme Court was not willing to extend the implied warranty that far. So as we see it, it's a very bright line. Just look to see if there's damage to a home. If there is, then perhaps there's an implied warranty. If there's not, there clearly is not. So for all those reasons, we think that the judgment below should be affirmed.
Okay.
Good afternoon. May it please the court. My name is Stephen Pickert for Applee T.D. Thompson Construction Company, a third-party defendant below. Mr. Brannick may not tell you this, but he was actually counsel of record in the Conklin v. Hurley Supreme Court case for the prevailing party. Therefore, I don't believe there's a whole lot more of significance I can add to Mr. Brannick's presentation, and I join in his argument. I would, however, like to briefly emphasize a few points. The first is that there have been several cases cited in the 6 different briefs submitted to you, and there's no reason to go to other jurisdictions to determine this case. There is long-standing, binding case law in Florida that controls this case, and that is Conklin v. Hurley, the Supreme Court decision, as well as the Port Sewell case out of the 4th DCA. Both cases came out of the 4th DCA. The underlying case in Conklin v. Hurley, Hurley versus Conklin, was written by Judge Downey. Port Sewell was written by Judge Downey, 2 years apart. There is no mistake about the 4th DCA's reliance on Conklin v. Hurley. If you read all the cases, you'll see that the focus since Gable versus Silver has clearly been on the house, the structure. What impacts the house or the structure? And in the Conklin v. Hurley case, or the underlying case, Gable versus Silver did a very good job of going through all the case law up to that point and the reasons why people buy homes and so forth. Hurley versus Conklin, the 4th DCA, did the same exact thing. And they said, it's the house, it's the house, it's the house. Or things that immediately support the house. And if I were asked that question, I would have said the line is, where are the things that immediately support the house? And in the Hurley versus Conklin case, the 4th DCA, they said it's the house and those things that immediately support the house, such as water wells and septic tanks. And there's one case out there at least that says, and it has to be built in connection with the building of that house. So you have this line there.
Is it your idea then, when they talk about immediate support, it has to be physical support and somehow physically attached to the house like a septic system?
Well, I think you could make that argument. I think you could make that argument with a straight face and with all credibility. But I also think it supports this concept that an implied warranty of fitness and merchantability has also been referred to as an implied warranty of habitability. So things that support the house mean not necessarily hold up the house, but are connected to the house, but it also means things that impact that implied warranty of habitability, and they use those terms interchangeably.
And I mean, I think I agree with you. I'm trying to understand, for example, if in Judge Griffin's hypothetical, the sewer system, if everyone agrees that the sewer or septic system would be within the implied warranty, but the drainage system would not be in Mr. Brannick's view, then what do you do, for example, if the entrance to the subdivision is a bridge and the bridge falls down or can't be used, and so the house itself is habitable, assuming that you could get there? I mean, I'm trying to understand, when we talk about immediate support, what did the Supreme Court intend by that term?
Well, in the Conklin v. Hurley case, they talked about the seawall, and if the seawall, and Justice Atkins in the dissent in Conklin v. Hurley said, well, if the seawall is 10 feet away from the home, there were no homes on that property, that seawall could collapse and eventually that home might collapse. But they did draw a line to immediately supporting. So there are causes of action for roads and bridges and drainage systems. But those things don't immediately support the home. I would, however, concede that if you're talking about a sanitary sewer line, which is not an issue in this case, or a water line that supplies water to a particular house, if the water line went down or the sanitary sewer line went down, as opposed to a septic tank or a water well, I would think under this analysis it would have an implied warranty of fitness and merchantability. But when you talk
that doesn't make any sense to me, that the water system that brings water to the house is covered, but the road that gets you to the house isn't covered. Why would that be?
Because if you look at the case law, Judge Griffin, going all the way back...
All we have is Conklin, and Conklin dealt with a bunch of investors. And that was, the court looked as much at who the buyers were in distinguishing Gable v. Silver as it did what was being purchased.
And you're correct, in Conklin they did that. And Justice Atkins again said, what's an investor?
I don't care about, I've written enough dissents to know that nobody pays attention to dissents.
Okay.
I'm looking at the majority opinion.
I agree with you there too. But in Loughran v. Engineering, this court said, we're not going to pay attention to the investor part of that. We're going to say this guy invested in a duplex. He's clearly an investor, but it's a septic tank. It clearly supports that structure. And that's what I was trying to get to, is the jurisprudence up to this point says the focus is on the house, on the house, on the house, on the house. And if it doesn't immediately support the house, and that's what Conklin v. Hurley does say, it has to immediately support the house. That's what Hurley v. Conklin said, and that's what Port Sewell said, is it has to immediately support the house. And as Judge McKinnon said in the trial court below, everything supports a house. The line is what immediately supports the house. It's not the guard shack up front. It's not the tennis court. And it may not even be the bridge across the creek that gets you to the subdivision. It's what immediately supports the house on that land. And the other point I'd like to make before I sit down is this.
Let me interrupt you with a question, if I may, though. You made a comment, and I'm looking very carefully to hear what the remedies are if this is not the remedy. And you made the comment that if it comes to the road or the bridge or the drainage system, those were the three that you chose, that there are causes of action to remedy those circumstances. So what are those causes of actions?
Judge Roberts, if you read the plaintiff's complaint in this case, he starts out with Maronda knew of certain defects and didn't disclose them to the association. There's a fraud count. There's a breach of fiduciary count. There's a negligence count against the construction. There's negligence in failing to detect the defects. There's negligence in failing to disclose or warn of known defects. And those are that's if you read that complaint, that's where I thought they were going when I first read the complaint and the amended complaint. But that's not where they went. They traveled on a single cause of action of implied warranty of fitness and merchantability that doesn't exist. And their answer to all those those theories is they're too hard to prove. So instead of taking a viable cause of action that might be a little difficult to prove, they chose a cause of action that has never existed. It doesn't exist, it's never existed, and there's long-standing case law, Conklin v. Hurley and Port Sewell, that says it shouldn't exist, and that's for the last 25 years.
Follow-up question that is, and this is more specific. If the definition is that these warranties apply to those things that directly support the house, why are we excluding drainage? And does it make any difference if we call drainage stormwater sewer?
Well,
I mean, if drainage is defective and a house is flooded, isn't it directly impacted?
the stormwater piping system is not connected to any house.
I realize that.
And
I don't.
And the retention ponds sit in the middle of, they're surrounded by houses, but they're not connected to the houses.
I didn't hear you defining impact as something that was physically connected to the house. I heard you defining it as something that had an effect on the house.
Well, I said
And under that, I'm thinking, well, if the stormwater sewer doesn't work, which is, the big drain and the big pipe in the front of the house by the road, or the swale system or something, if the retention pond, if that doesn't work and the house is flooded, is that not an impact? That's what I was hearing. So
it may be an impact, but it doesn't immediately support the house. Like Judge McKinnon said, everything supports the house. There's no question about that. If you're in the airline path and you get airlines crossing your airspace every day and it dumps chemicals, that's an impact. But you have to draw the line, as Judge Orfinger said, and the line has been drawn by the Florida Supreme Court, and that is those things that immediately support the house.
Thank you, Mr. Baker.
Quickly on rebuttal, and thank you for the extra time. I would like to make it clear that we have alleged drainage problems to the lots. That was referenced in our complaint. It's referenced in the motion for summary judgment, the memo of law supporting it, and also the affidavits. So we have alleged those drainage issues that actually impact and affect the
And what is it you've alleged that is defective, causing a lack of drainage on those lots?
Grading issues, Your Honor. There are issues with the underground pipes that take the water away from the lots. So we've also alleged defects and errors with regard to the installation of those. And then,
This is stormwater drainage? Is that what you're talking about?
yes, Your Honor.
So why isn't the remedy, as they propose, negligence against the engineer that designed it, or some sort of negligent construction?
Because, Your Honor, that's not a complete remedy. Us being able to find perhaps one of the issues being poorly designed and therefore the remedy can be against one individual design professional isn't the full remedy that an implied warranty would give. Secondly, Your Honor, this court in Loughran
Why isn't it? Why?
Because these aren't just design issues and design problems. We've actually got issues out there, for instance, with underground pipes where they were not wrapped properly, and so dirt is pouring into the pipes and filling them up. That has nothing to do with how they were designed. They were designed properly. The design professionals said wrap the pipes. Well, they didn't wrap the pipes, and they were installed incorrectly. So we would have no theory of recovery against the design professional. Another problem is with the.
Wait a minute, but that doesn't necessarily mean you're without adequate remedy. You just yourself said that somebody didn't properly wrap it, so wouldn't your remedy be against that entity?
Well, Your Honor, that would be possibly precluded by the economic loss rule. In fact, in the Loughran case, which has been mentioned a lot today, that's exactly what this court said. The property remedy for recovery is not for the tort of negligence, but for the breach of warranty implied by law by consumer protection-reminded courts in the sale of real estate as an exception to the late common law rule of caveat emptor. So this court's already said that it's not negligence as being the cause of action. Moving to fraud, that was one of the causes of actions that was mentioned. That's a remedy without a remedy. We're a homeowners association. We're bringing this on behalf of all the owners as a class action. You can't bring a class action cause of action for fraud. So the very first thing that we would get is a motion to dismiss or a motion for summary judgment, and they'd win. So all these different theories that they keep mentioning as being remedies aren't remedies. The only remedy that the association has that is full and complete is the remedy that a condominium association has in the exact same circumstance, and that is implied warranties. The next thing that I would like to say very
Can you make
quickly.
sure I understand your issue on the economic loss rule, please, sir? So if the design professional says wrap the pipe and somebody doesn't wrap it, and it costs, $500,000 to put in all the pipes and wrap them, but now to replace them it's going to be $1 million, are you saying that because of the economic loss rule under negligence theory, you cannot recover the cost of proper replacement of those pipes? Is that what you're saying?
I believe that could definitely be the case, Your Honor. And, there's the privity arguments in the economic loss rule that we would have to look at.
Because if you're not in privity, you're not impaired by the economic loss rule.
Right.
And I will be the first to admit that there was a time when I thought I understood the economic loss rule, and that time's long past. I mean, I can't even begin to think it through on the fly. But it seems to me like a basic premise of the economic loss rule is that there is a contract between the parties as the starting point. And in this case, for example, if you brought a contract against whoever installed the pipes, I don't know if that's Mr. Pickard's client or whoever it might be, you're not in privity with them, so I'm not sure how the economic loss rule would.
And that would definitely be an additional cause of action that the association would be able to consider. But we should also be able to move forward against the developer that set up this entire scheme and development. And we should be able to recover from that developer who then seeks recovery and indemnity from other parties and whatnot. We should not be required to seek out, piecemeal exactly who constructed every single element in a community. That's not what's required for a condominium association, and it shouldn't be required for a homeowners association. There's no reason for the distinction.
Counsel, I'm going to have to stop you there.
Okay.
Exhausted your time.
Thank you very much.
Thank you all very much for a good argument, and that's the last case of the morning, so we'll be in recess until Thursday.
Thank you.
Thank you all.